From your experience researching in this area, do you think that the proposed approach is desirable, or would you like to see the bill modified? And if so, how would you like to see it modified beyond what you've said already?
Well, look, I don't have a real a definite view on that matter. I think that guidelines are provided to the Charity Commission of England and Wales and so forth, so you can provide guidelines which would be subject future time to legislative oversight and review. But if you want, I think it's a matter for senators really, if you think these matters are of the utmost public importance and interest and controversy, put them into the main bill. So that really is of no great concern to me. I think the main thing is that the provisions are enacted.
Okay, thank you, Dr. Mutch. Senator Cameron?
Yeah, thanks, Dr. Mutch. The Productivity Commission indicated that the benefit to charities in relation to public funding was between $4 billion and anywhere between $4 and $8 billion. You indicate that the whole approach is based on an arcane approach and a medieval presumption. Do you want to just expand on why we should take a more modern approach to $8 billion of public money?
I think so. I think that if we're going to privilege organisations, we should make sure that we do so on proper public policy grounds, not on some old presumption that a group is necessarily for the public benefit. And there is an awful lot of taxpayers' money that is not necessarily wasted. I mean, it's in fact it's put to good use if these organisations are genuine. If they're genuine organisations, they're providing a very good service to the citizens of this country. But a few non-conforming groups, seemingly the ones that want to take as much money as they can out of the hands of the people that are their adherents, and often spend that money on litigation against their critics, those types of groups, well, maybe they should be looked at in terms of their tax relationship with the state.
You say there's a few non-conforming groups. Some of the submissions we've had from other organised religions is that, excuse me, they shouldn't be disadvantaged because there are a small group of non-conformers. You should deal with the non-conformers and you shouldn't make law generally on the basis of an exception. What's your view on that?
Well, I think that's what this bill proposes, doesn't it? It sort of sets up a general system whereby not a great onerous responsibility performing and genuine groups can show a public benefit. I mean, there might be other ways. There's different ways of approaching this that you could certainly look at. You could have a trigger mechanism. If there's an administrative problem in making sure that every group has to prove public benefit, you could have a different system set up whereby the ATO is giving guidelines on when it triggers a reversal of the presumption and then goes along and tests a particular entity based on the guidelines that I think are very properly provided under this bill. Because if anything, this submission by the ATO shows to me that they are crying out for more legislative guidelines in this area.
Yeah, Dr. Mutch, the submissions that we have, some say that all of the issues that have been raised in relation to this inquiry can be addressed by the existing agencies using the existing powers, and much has been made of taxation ruling TR 2005/21. Do you have a view on that?
Well, only that that's always said, isn't it? You know, that could very well be the case when you're looking at particular criminal activities of an organisation. But if you want to apply a test to an organisation that should be for the public benefit, I think the agency that we're looking at here is the Australian Taxation Office. So it's a fairly specific thing. And I don't see any problem with that.
Yep. Are you aware of the changes that have been made in the UK, Scotland, Ireland, in relation to the establishment of a commission?
Interestingly enough, to some extent, I must say that my focus was up until the end of my PhD, and I've had very little time to revisit the taxation issues involved. But Interestingly enough, it seems to me that prior to the changes in the United Kingdom, for instance, there was a very important case where Scientology, as an example, it was a case involving Scientology with the Charity Commissioners of England and Wales. They did examine that organisation with respect to its taxation as an entity. They actually ruled it out on the basis of definition. They said that it didn't comply with the second prong of the definition being worship. But they also then went on in that Charity Commissioner's case to examine questions of public benefit, and they said that they would have reversed the onus without any problems whatsoever. And the test that the things that they looked at there included adverse comment in the public, adverse comment from the judiciary, and so forth. And they used all those sorts of evidence to say that they would have reversed that onus, and then they would have looked to whether or not the public benefit was provided by that organisation, and they would have concluded that it wasn't, because if there was any benefit at all, it was more in a private capacity for the auditing and counselling services that Scientology charges money for.
The charities, you indicated that I'm not sure if this is the word you used, but like the organised religious groups in the UK are working quite well and effectively with the Charities Commission. Is that
well, look, I don't have any direct knowledge of that myself, but that was what the ATO have said. That's what the Treasury submission says. And I think we must rely very much upon their expert advice. So I would rely upon that.
Senator Xenophon.
Submission and your work in this area. In relation to the 1999 Charity Commission decision in New South for Charity Commissions for England and Wales, in relation to the Church of Scientology, is it your understanding in respect of that decision that in order to determine public benefit, the commissioners looked at issues of public detriment and harm?
Well, it's an interesting question, because they looked to those issues on the basis of whether or not the presumption should be reversed. And then they applied further analysis of previous cases as to whether or not once they said that there's no problem here reversing the presumption, we're very concerned about these issues. So they did take all those things into account. And I think it's very unsatisfactory. In my thesis, I actually think that the system then was also very unsatisfactory in the United Kingdom, in the sense that they were relying upon newspaper reports, they were relying upon some adverse commentary in the cases and so forth. And even then I thought, well, that's not really good enough in terms of the need to balance detriment against harm, which I can't see any way of avoiding that need. I think you really need to weigh those considerations up. And if they need further guidance, I think that's good, because it was provided in the United Kingdom.
Sure. And insofar as the Charity Commission of England and Wales is looking at issues of, it weighs up, it has a balancing act of weighing up both detriment and benefit, do you see it as relevant in the framing of any regulations pursuant to this bill?
Yes, because
sorry, if I can just finish. Yes. Sorry. Do you see it as relevant to actually ensure that in framing regulations there is evidence or consideration given to issues of conduct and individual cases in order to frame those regulations?
Well, how could you not take into account individual concerns and complaints? I mean, what does the ATO act upon now, for instance? I mean, is it an individual concern or complaint that they happen to receive? Is it they happen to speak to someone in their family that knows about something? I mean, it seems a bit unclear to me as to what triggers them to take the decision to reverse the presumption and then apply some sort of test. Now, the ATO's application of the test is extremely narrow and limited, because they're only confining themselves, once the onus is reversed, to looking at some specific decisions that have been made in the courts in England, essentially, because most of the examples they've used here are English examples. And in fact, I'm not even sure that they would look at the Charity Commission's decision, because is the Charities Commission decision a court decision? Because it's a quasi-judicial body. Interestingly enough.
Because I'm concerned about time constraints, a couple of things